Geordie Unwin, on 2 February 2026, you pleaded guilty to the following charges. Charge 1, conduct endangering life, and Charge 2, recklessly exposing an emergency worker to risk of safety by driving. The circumstances of your offending were not disputed by you and are described in a summary of prosecution opening dated 29 January 2026. I will briefly summarise these circumstances. You were 28 years old when you committed these offences while driving a Holden Commodore. At approximately 8:40 p.m. on 3 April 2025, police received numerous calls from members of the public reporting that this vehicle was running red lights and driving on the wrong side of the road on Peel Street, Ballarat. Over a 20-minute period of time, police received more than 20 calls regarding this vehicle. It was last reported that the vehicle was driving at a fast rate of speed against the flow of traffic in the westbound lane of the Western Freeway. At that time, it was wet and dark and the road was busy with cars and trucks. The Western Freeway where you were driving is a divided highway with 2 lanes of traffic travelling in a westerly direction. You were travelling at a fast rate of speed in an easterly direction. The opening describes you driving past at least 11 separate vehicles. You were on the wrong side of the road, and a number of those drivers had to take evasive action to avoid a head-on collision. Some of the vehicles you drove past had dashcam cameras that captured footage of your vehicle travelling in the wrong direction. Footage was played to the court. It can be seen how some of the vehicles travelling west were in the process of moving into the right-hand lane to overtake a vehicle and then saw the lights of your vehicle. Fortunately, the drivers were able to stop the overtaking manoeuvre and move back into the left lane as you passed them. Your driving against the flow of traffic on the Western Freeway constitutes the charge of reckless conduct endangering life, an offence that carries a maximum penalty of 10 years imprisonment. Charge 2, recklessly exposing an emergency worker to risk by driving, also carries a maximum penalty of 10 years imprisonment. The circumstances of this offence arose when a police officer, leading Senior Constable Nolan, was notified of your driving and tried to stop you. He drove towards your reported location in a marked police vehicle with its lights activated. He drove his car in a westerly direction in the right-hand lane of the Western Freeway and saw your vehicle driving directly towards him on the wrong side of the road and travelling against the traffic at a fast rate of speed. You did not slow down or change lanes, and leading Senior Constable Nolan quickly turned his vehicle to the left in order to avoid a head-on collision. It is this particular near collision with leading Senior Constable Nolan's vehicle that constitutes charge 2. After you drove past the police car, you continued to drive in an easterly direction against the flow of traffic. Leading Senior Constable Nolan made a U-turn and managed to catch up to your vehicle by driving in the eastbound lane. He saw your vehicle involved in numerous near-miss head-on collisions. Leading Senior Constable Nolan then managed to drive ahead of your vehicle and park his vehicle across the westbound traffic lane. He then got out of his car that still had its emergency lights activated. You managed to brake just before where leading Senior Constable Nolan's vehicle was positioned. You then made a U-turn and travelled west. At 9:27 p.m, police received reports that you'd stopped your vehicle and were running and jumping in front of traffic travelling on the Western Freeway. At about 10 minutes later, police were able to arrest you on the Old Melbourne Road exit in Ballon. You were taken to hospital and then to Ballarat Police Station, where after arrest, you were interviewed on the afternoon of 4 April 2025. You provided a no-comment interview, although you confirmed the Commodore was registered to you and that your possessions were in the vehicle. Your personal circumstances are outlined in your counsel's written submissions and expanded upon during the plea hearing. They are also referred to in previous sentencing reasons given when you were sentenced for aggravated burglary in this court in October 2021. You have Aboriginal lineage through your father, although connection to your family history has been limited. Your father struggled with alcohol problems and poor mental health and worked in abattoirs. Your mother works as a nurse. You have a younger brother and a younger sister. Your parents separated when you were approximately 14 years old, and you lived with your mother and your siblings in country Victoria. You left Colac Secondary College in Year 12 and have worked predominantly in abattoirs. Unfortunately, you started taking illicit drugs as a teenager. Methamphetamine use has been a significant problem for you at various times during your adult life. You had limited contact with public mental health system in early adulthood. However, your counsel, Ms Casey, has indicated no reliance is placed on the principles in the case of Verdens relating to how mental health issues may bear on certain sentencing factors. You have had an intimate relationship with a woman lasting 5 years, and you share 2 daughters who are now aged approximately 5 and 6 years old. They reside with their mother in Sale, and you have contact with them mainly through your mother. You were living with your brother and your father in Tongala immediately before your offending. Your counsel went through your father's history and your grandfather's history. Both apparently had significant alcohol and mental health issues. At the time of your offending, you were unemployed and looking for employment, but struggling with methamphetamine use. Your counsel explained that despite your personal struggles, you have a positive attitude to employment. You have worked for a considerable time in abattoirs, but your ideal work would be related to your love of fishing. You had made an application and been interviewed to work in a camping and fishing store, but unfortunately you were not successful in obtaining that employment. You have a limited criminal history. You have 3 prior road traffic matters, 2 of which involve magistrates' court proceedings and 1 involving a traffic infringement notice. In 2019, you failed to have registration plates displayed and you were fined without conviction. In 2020, you were issued with a traffic infringement notice related to you failing a blood or oral fluid test, and you lost your licence for 6 months. In April 2025, you were fined $600 without conviction for careless driving. In October 2021, you were sentenced for aggravated burglary in this court. I have read the sentencing remarks relating to that case. While any aggravated burglary is serious offending, the judge regarded the circumstances of that offending to be in the lower mid-range of seriousness for offences of that type. You were regarded as a youthful first-time offender who had engaged in rehabilitative programs, who had acted out of character and had good prospects for rehabilitation. You had engaged in mental health services and been treated with olanzapine. You were sentenced to a community corrections order of 18 months duration with various conditions, including unpaid community work. Your counsel relied upon the fact that you completed the community corrections order previously imposed, and that since 2021 you have had only 1 other court appearance in the Magistrates' Court where you were convicted and fined $500 in relation to possessing ammunition without a proper permit. While you do not come before the court as a first offender, it is conceded that your prior criminal history is of little relevance to the current sentencing exercise. Your counsel has submitted the following matters in mitigation. You are relatively young, being 28 years old at the time you offended and 29 years old now. You have family support, particularly from your mother and a cousin, and it should be noted that your mother and her partner were present in court supporting you during the plea hearing, and I can see that they are also present in court today. You have demonstrated periods of abstinence from illicit drug use. In particular, you complied with a significant period of bail conditions before you were sentenced in 2021, and then there were no incidents of concern regarding your compliance with the 18-month community corrections order. You have pleaded guilty at the earliest opportunity and are remorseful. I was told your mother will provide you with accommodation near Colac when you are released from custody. You have engaged and completed multiple courses while undertaking your first period of custody, and your prospects of rehabilitation are positive. Your counsel submits that the above factors warrant a sentence of imprisonment in combination with a community corrections order, and further that the period of custody on remand since 4 December 2024 is a sufficient period of imprisonment in combination with a community corrections order. In support of the above submissions, your counsel also referred to your First Nations heritage and how you were interested in strengthening your connection to your culture. Tendered on your behalf were images of paintings you had completed in custody. These images were impressive and indicated you are a talented artist. It was submitted that a possible condition of a community corrections order could involve you undertaking a Walgungu Ngalo learning program that would enable a deeper connection to your cultural heritage. Tendered on your behalf were certificates from courses you have undertaken since you were remanded in custody. You've completed courses related to jobs and careers, applied digital devices, first aid courses related to hospitality and occupational health and safety, as well as pro-social life skills through social skill development. You've completed 20 hours of practical workshops. You've also completed programs exploring the impact of substance use on mental health, as well as a 27-hour program specifically related to the adverse impacts of methamphetamine use. You've also completed educational programs related to Indigenous history and culture. The prosecution conceded your efforts at rehabilitation whilst in custody should be taken into account in moderation of your sentence. However, the prosecution submitted that these efforts have been in a custodial setting, which creates some uncertainty as to how you will progress on a rehabilitative path when released. The prosecution's position is that your offending is simply too serious in terms of the risks created to numerous members of the public and leading Senior Constable Nolan to result in anything other than a sentence of imprisonment with a head sentence and non-parole period. Mr. Unwin, the purposes of sentencing include considerations of specific deterrence, general deterrence, denunciation, protection of the community and rehabilitation. Sometimes these considerations pull in different directions. I accept that you are remorseful for this offending. I also accept that you are making genuine efforts in custody to learn strategies to make sure you do not use illicit substances in the future. You have demonstrated that you have taken the conditions of a community corrections order seriously in the past and have completed quite an onerous order. I must consider whether imposing a sentence of imprisonment in combination with a community corrections order would be a just and proportionate sentence. I have not been able to reach that conclusion because of the seriousness of your offending. Your driving on this evening was truly terrifying. To travel in darkness on a wet divided highway in the opposite direction to oncoming traffic was extremely dangerous. The dashcam footage shown to me during your plea hearing vividly depicted the risk you posed to other road users. A truck was visible in some of the footage in front of one of the vehicles travelling in the opposite direction to your vehicle. Fortunately, the drivers travelling west were attentive and were able, when necessary, to avoid travelling in the lane in which you were driving. Had they been in the process of overtaking a truck, this may have been more difficult. An element of charge 1 is that the offender foresees that his conduct would probably create a risk, an appreciable risk of death. I regard your offending as a serious example of this offence. The risk posed by your driving was not transient and placed a number of people in cars that you passed travelling at a relatively high speed at great risk. A number of those drivers had to take evasive action to avoid what undoubtedly would have been a catastrophic collision. Leading Senior Constable Nolan included in his statement just how shocked and traumatised he was by having to evade your oncoming vehicle. He stated that it left him feeling sick and shaking and that he felt lucky to be alive. Although no victim impact statements have been formally tendered, it would be understandable if the other people you passed in your vehicle that evening had similar responses. There was some discussion during your plea hearing regarding section 16(3)(d) of the Sentencing Act that provides that unless it is otherwise directed by a court, a sentence imposed in respect of charge 2 should be served cumulatively with other sentences imposed. Your counsel submitted that your driving towards leading Senior Constable Nolan was part of the one episode of driving and no different to the risks caused to other drivers. The sentence imposed for that charge should be concurrent with charge 1. While I accept the factual basis of that submission, in my view, an important policy objective of this law is to recognise the unique obligation imposed upon emergency workers to assist and protect members of the public, and that sometimes that obligation may involve interactions with offenders. Parliament, through this provision, seeks to deter acts that place this particular group of people at risk. It is apparent from viewing the footage from leading Senior Constable Nolan's vehicle that he quite bravely put himself in harm's way in an effort to perform his duty. He had to drive at speed on a 2-lane highway in the dark towards what he believed was an approaching oncoming vehicle. He did this as part of his duties as a police officer. It's not really disputed that you would have been able to see the flashing lights of the police vehicle. Indeed, it is an element of the offence that you knew or were reckless as to the fact that leading Senior Constable Nolan was an emergency worker. A police officer is defined by law to be an emergency worker. Despite the police vehicle travelling towards you with flashing lights head on, you did not appear to slow down or change lanes. An element of this offence is that you recklessly exposed an emergency worker to a risk to safety. This offending was, in my view, a serious example of this offence, as this particular risk to safety was a very significant risk. While I am prepared to allow for a period of concurrency given considerations of totality, and taking into account that this was part of the one episode of continuous offending, in my view, the purpose of this provision requires a significant proportion of the sentence for this offence to be served cumulatively upon the sentence imposed on charge 1. It was never made clear during your plea hearing why or how you came to be driving on a divided highway in the opposite direction to the flow of traffic. But once you approached and passed a car travelling in the opposite direction, it must have become clear to you just how dangerous your driving was. You continued to drive in this manner. The precise time you drove in this manner was not completely clear from the material, but it was certainly not transitory. It was not disputed that you passed at least 7 vehicles travelling in the opposite direction, a number of which had to take evasive action. Mr. Unwin, there's no issue that you have pleaded guilty at the earliest opportunity, and that warrants a significant reduction in your sentence. You have expedited the criminal justice system and saved expense and time. I also accept that you are remorseful and you are doing everything you can to increase your prospects of rehabilitation. Given your limited criminal history and previous compliance on a community corrections order, I regard your prospects of rehabilitation as reasonable. No doubt the programs you have undertaken in custody will have brought home to you just how interrelated your successful rehabilitation is to your ongoing abstinence from illicit drug use. It is fortunate that you have family support. I have had regard to the cases that counsel have suggested are comparable and which provide some guidance to sentencing practices for this type of offence. While the cases have given me some indication of the types of sentences imposed relating to charges of this type, each case has very different circumstances from your case. This is not unusual, as each case for offending of this type is likely to have very particular circumstances, both in relation to the circumstances of the offending and the personal circumstances of the offender. The cases provide some guidance, but are not precedents. I must impose a sentence that is just and proportionate, and no longer than is necessary to reflect the balancing of the various purposes of sentencing. While I have formed the view that your offending is too serious to result in a combination of jail and a community corrections order, the matters in mitigation have led me to impose a lower sentence than I would have imposed without those factors being present. Balancing as best I can the purposes of sentencing and having regard to the submissions of the parties, the material tendered and all relevant matters, I have determined that you should be sentenced as follows. On charge 1, you are convicted and sentenced to 2 years and 4 months imprisonment. This is the base sentence. On charge 2, you are convicted and sentenced to 20 months imprisonment. I direct that 8 months of that sentence is to be served concurrently with the sentence being served on charge 1, and 12 months is to be served cumulatively upon the sentence on charge 1. That makes a total effective sentence of 3 years and 4 months imprisonment. I further declare that you serve a minimum of 2 years and 3 months imprisonment before being eligible for parole. Pursuant to Section 18 of the Sentencing Act, I declare that you have already served 320 days pursuant to this sentence, and this period will be entered into the records of the court. Pursuant to Section 6AAA of the Sentencing Act, I declare that had you not pleaded guilty to these offences, I would have sentenced you to a total effective sentence of 5 years imprisonment with a non-parole period of 3 years and 8 months. According to the provisions of the Sentencing Act, you've committed a serious motor vehicle offence. Whilst the minimum period of disqualification for such an offence is 24 months, in my view, it's necessary to cancel all motor vehicle licences and disqualify you from obtaining any licence for a period of 30 months from the 2nd of February of 2026.